Economic Development, Public Buildings, and Emergency Management Subcommittee. One of the purposes of this committee is to protect taxpayer dollars by ensuring that they're spent effectively, efficiently, and with transparency. That brings us to today's hearing, which is entitled Landlord and Tenant, the Trump Administration's Oversight of the Trump International Hotel Lease. You can tell from the title that today we're going to be investigating a fairly unprecedented situation. The federal government owns the building that houses President Trump's D.C. hotel. Since President Trump has declined to divest from his businesses, he's essentially acting as both the landlord and the tenant. Before I was elected to Congress, I spent over 3 decades teaching college students about American government and politics. In those classrooms, we had serious discussions about the role of the legislature holding the executive branch accountable to the highest legal and ethical standards, and that's exactly what we hope to do today. So first, let's start with some facts. 1, all federal workers and federally elected officials take an oath to uphold the U.S. Constitution. And of course, that includes the president, all members of the administration, and all of us in Congress. Second, the Constitution contains 2 clauses that are pertinent to our topic today. One prevents an elected official from receiving, and I quote, any present or emolument from any king, prince, or foreign state without the consent of Congress. To date, Congress has given this president no such consent. A second and related clause prevents the president from accepting any federal or state taxpayer dollars or emoluments beyond his presidential salary. Now, a lot of people may not be familiar with the term emolument, but the Founding Fathers thought of it broadly as any payment or benefit. They included it in the Constitution to prevent U.S. government officials from accepting bribes from foreign governments or from parts of our own government that might be trying to curry favor. I hope we can all at least agree that that's a practice that the public and the members of this Congress don't abide. Third, the government lease for Trump's D.C. hotel explicitly states that the tenant may not use the premises to violate federal law, quote again, for any purpose or in any way, and that, of course, includes the Constitution. Moreover, Section 37.19 of the lease states that no elected official of the government of the United States shall be admitted to any share or part of this lease or to any benefit that may arise therefrom. Yet the president continues to have a personal stake in the hotel. When people stay at Trump's D.C. hotel, he directly benefits. Yet despite all the legal and ethical issues that arise from this unprecedented situation, the agency that oversees the lease, the General Services Administration, has not done a thing about it. In fact, the agency's independent inspector general, who is here with us today, conducted an exhaustive report that found that the GSA recognized that the president's business interest in the old post office lease raised issues under the Constitution's emoluments clause that might cause a breach of lease. Despite this observation, the inspector general found that the GSA decided not to address those obvious issues. The inspector general called that improper. Well, I think that's kind of the least of it. When you take an oath to uphold the Constitution, you're bound by that oath. Yet GSA officials have turned a blind eye to these legal and ethical issues. When called on it, the GSA failed to implement basic recommendations made by the inspector general. GSA was instructed to conduct a formal legal review that includes consideration of the Constitution's emoluments clauses and the terms of the lease. As far as I know, GSA hasn't even pretended to conduct that review. GSA was also instructed to revise the language of their leases to make it even clearer that the Constitution is relevant. They haven't done so in any way that satisfies the Inspector General, and they haven't done so in any way that satisfies this committee. Finally, in addition to the legal issues, GSA has refused to turn over documents to this subcommittee, which has the jurisdiction over GSA and that we have a legitimate purpose to examine. In 2008, Congress directed GSA to lease out the old post office building in order to make a profit. Yet GSA, relying on the opinion not of their attorneys, but of the Trump's business lawyers, refused to turn over any basic financial documents that could help us determine if they are upholding the terms of the lease. How can we know that taxpayers' investments are being protected if we can't examine the financial records of the hotel? And how can we ensure that national policy is not being swayed by those spending money at the hotel that benefits people at the highest levels of our government? GSA is also preventing us from looking at legal memos that were drafted when government officials who were supposed to enforce the terms of this lease decided to look the other way. It's shameful, and yet it's what we've come to expect from an executive branch that continues to stonewall Congress and rejects transparency at every turn. Few could have ever imagined a situation like we're in today, but the Founding Fathers were wise enough to put the Emoluments Clause right in the Constitution, and we should be wise enough to enforce it. In our first panel today, we will hear from the agency that oversees the D.C. Trump Hotel lease and from the Inspector General, who found that the GSA did not fulfill its obligations under the Constitution. In the second panel, we'll hear from legal scholars who can shed more light on some of these pertinent issues. I want to thank the witnesses for being here today. I look forward to hearing your testimony and answering our questions, and I now recognize the ranking member, Mr. Meadows, for an opening.